Hi friends, you would have seen the news that Dhanashreeverma divorced Yuzvendra Chahal and she got 4.75 crore as alimony. Now the big question is this money taxable? As a general rule, who pays this alimony? It is generally the financially stronger spouse would pay alimony to the financially weaker spouse. Well, the family courts decide the amount of alimony based on various factors. It could be the earning capacity of both the spouses, financial dependence, property and assets, standard of living before divorce, age and health, duration of marriage, custody of children, debts and liabilities, so many factors. So, Indian laws recognize the husband's duty to maintain the wife after divorce or separation. So, typically, courts usually award 25 to 33% of the husband's income as alimony or monthly allowance. And in case it's a one time lump sum payment, then roughly around 20% or 33% of the husband's income would be treated as alimony. But if the wife is financially independent, she may also end up getting a lesser amount of alimony. That's probably what the case has been with Yuzvendra Chahal being 4.75 crore. So we have the Hindu Marriage Act of 1955, which speaks about interim and permanent maintenance. And as per Muslim law, the Muslim husband is required to pay meher or maintenance. Ideal period would be 3 months after divorce, after which the wife would seek maintenance from the relatives, as we saw in the landmark judgment of Shah Bano case way back in 1985. And the Christian Marriage Act has to be read with the Indian Divorce Act, where Section 37 of the Indian Divorce Act says that yes, alimony has to be paid. And there are many such laws governing it. There is a Special Marriage Act for the interfaith couples. All the laws protect the financially weaker erstwhile spouse. Interesting question is, can husbands get alimony? Of course, yes. If the wife is financially well off and the husband has no means to earn, then definitely it would alimony would be paid to the husband, as decided in a case in 2017, that is Kanchan versus Kamalendra, where the alimony was awarded to the husband. The next question is, can Dhanashreeverma challenge this decision of 4.75 crore in a higher court, let's say a district court, a high court or Supreme Court? Yes. But there should be a proven wrongful calculation, misinterpretation of facts, or a significant change in the financial status. Those only would be the grounds of appeal. And there have been some couple of cases, that is Anju Garg case of 2009 and also Rajneesh versus Neha in 2020, where based on an appeal, the alimony has been revised. So can alimony be stopped also? Yes, if the recipient spouse remarries, it may be stopped, or if the payer loses their job, then that also may be stopped. Of course, it should go through the court process. Now friends, coming to the main point, is alimony amount taxable? Now alimony can be three types. One is a lump sum payment, second would be a monthly payout, and third would be mere transfer of assets. Let's take it up one by one. First of all, lump sum payment. Now income tax law recognizes income which is taxable, but it distinguishes that from a capital receipt which is usually not taxable. Now lump sum alimony and even the asset transfer are considered as capital receipts because they are just compensation for the loss of financial support after divorce. So hence it is not taxable. It is also subscribed by a Supreme Court judgment, Kanti L. Jadhav, in 2015, where they held that the alimony is not to be considered as income. Similarly, if I transfer an asset instead of cash, if Dhanashree would have got a 4 crore worth of a house, would that be taxable? No, because Income Tax Act defines something called as a transfer, which is taxable under Section 47. But in that transfer, there is no mention of transfer of asset during divorce proceedings, because of which any transfer made by one spouse to another as part of alimony would not be taxable at the time of transfer. However, let's say Dhanashree received a house worth 4 crore, and after a couple of years or of next year, if she's transferring that house or selling that house, would capital gains tax apply? 100% yes. In that case, the capital gain tax would apply. The cost of the asset would be whatever cost Yuzvendra Chahal had bought it for, and even the period of holding would be counted from the time Yuzvendra Chahal had bought that house. So everything will flow from the previous owner. So eventually it is taxable, but not at the time of alimony, but at the time of sale of that particular property. But interestingly, what about monthly or periodic payments of alimony from one spouse to the other? Regular monthly alimony is considered as income from other sources under 56(2). It was also held in a case law, that is a very old case law of 1984, Princess Maheshwari Devi of Pratapgarh, where the court held that recurring alimony would be considered as income. So this is an interesting point. If it is monthly, it may be considered as income. But let's think once from the point of view of the payer. A question that begs to be answered is, would he have some peace of mind? Or would all that is left would be pieces of his mind when he loses all money to alimony? I'll be waiting for your views. Cheers.